Whenever the Supreme Court, especially today's remade Supreme Court, takes on an abortion case, emotions run high. And this Louisiana case is a big deal. For the Colson Center, I'm John Stonestreet. This is Breakpoint. Last week, the Supreme Court heard oral arguments in the most important abortion case since Whole Women's Health versus Hellerstedt. In that 2016 case, the court struck down a Texas law that required abortion clinics to have admitting privileges at a hospital within 30 miles of their location. The court said that such a law placed undue burdens on a woman's access to abortion. That law would have led to closing about 75% of Texas's abortion clinics. So far, the headlines about the case heard by the court this past Wednesday have mostly been about Senate Minority Leader Chuck Schumer threatening Justices Gorsuch and Kavanaugh, but there's much more at stake in June Medical Services versus Russo. This case involves a Louisiana law nearly identical to the Texas law struck down by the court. Now, note here, I'm emphasizing the word nearly. Despite what you may hear from the New York Times and elsewhere, the laws are not identical, especially in how they'd play out on the ground in their respective states. That's why, after a federal district court initially struck down the Louisiana law based on the Texas law precedent, the Fifth Circuit reversed the district court ruling, with the majority opinion citing two important ways the Louisiana law and the Texas law are different. First, the Louisiana law would only affect about 30% of women seeking an abortion. Second, the requirements for doctors to obtain admitting privileges are less strict in Louisiana than Texas, meaning abortion providers could more easily comply with the law and fewer would be forced out of business. With those differences in mind, the circuit court concluded that the Louisiana law did not impose an undue burden on a woman's access to abortion. So, here we are, just 4 years after deciding Whole Women's Health, a recently remade court is agreeing to hear a case which could overturn precedent and create significantly more elbow room for state-level restrictions. The whole thing has abortion rights advocates, shall we say, a bit nervous. Much of the oral argument centered around what constitutes an undue burden. Chief Justice Roberts raised the possibility that the issue was a factual one. What may constitute an undue burden in one state might not in another. Factors such as the number of clinics and doctors in each state, in light of the geographic size and population of the state, should be considered. But the lawyer for June Medical Services rejected that idea and insisted that because requiring admission privileges serve no medical purpose, it would always pose an undue burden. That prompted Justice Kavanaugh to ask whether such a requirement would have any effect on the availability of abortion if, for instance, every doctor could get such privileges. Well, the lawyer just repeated her answer, that an admission privilege requirement serves no medical purpose. And her answer was telling. Apparently, any regulation of the abortion industry above bare minimum is unacceptable, whether or not it has any real-world impact on the availability of abortion. You see, ultimately, this case is not about the availability of abortion in this one state. It's about the nearly unique status that abortion laws hold in our country. Unlike virtually every single other right, like freedom of speech or religion, any limitation on abortion, no matter how small, is considered a mortal threat to abortion rights and cast as part of a war on women. It's difficult to know how this case will turn out. The Supreme Court always seems reluctant to overturn prior rulings, even closely decided one like Whole Women's Health, or to issue sweeping rulings, especially about issues on which America is so deeply divided. My prediction is that the court will narrow the reach of that 2016 decision, leaning on the factual differences between the states and the cases. While such a decision certainly wouldn't be the end of Roe, it could incentivize additional state-level innovations to restrict abortion, which would mean, as we've often said here, that our fight against the evil of abortion would only intensify, and that local-level activism would only become more important. After all, the goal is still to make abortion unthinkable, not just illegal. And that's our job, not the court's. For Breakpoint, I'm John Stonestreet.